Okay, and Mr. Watts, the court, and thank you, Joe, for taking that up. And Mr. Watts, I am in receipt of the competency evaluation from South Central Mental Health. Court goes on the Zoom record. Case is entitled State of Kansas versus Anthony Michael Alfaro, 25 CR 51. State of Kansas appears by Assistant Butler County Attorney Amber Norris. The defendant, Mr. Alfaro, appears in person, and by court-appointed counsel, Jim Watts. Also appearing at this time is Community Corrections Intensive Supervision Officer Christy Ashenfelter and Ashley Nelson with Substance Abuse Center of Kansas. This matter does regularly come back before the court on the warrant to show cause docket. The court is in receipt of correspondence from South Central Mental Health, which Mr. Watts has forwarded. And the court finds that South Central Mental Health has advised that Mr. Alfaro, in its opinion, date of report, March 30, 2026, evaluation date 3/30/26, that Mr. Alfaro is competent to proceed in regards to this warrant to show cause matter. An announcement to the court, Mr. Watts.
Well, first, Your Honor, as to the South Central Mental Health report, after speaking with Mr. Alfaro this afternoon, I don't dispute the mental health report, would ask the court to accept same.
Court does accept the same. And recommendation, or excuse me, means and method of disposition of Mr. Alfaro's case, Mr. Watts.
Thank you, Your Honor. As to the other matter, there's a warrant to show cause, and it's been a while, as I noted, Mr. Alfaro to get here. Was arrested November 21 for a warrant to show cause file on November 5. He would stipulate that he failed to maintain employment, that he tested positive for methamphetamine, that he had not made monthly payments, was unsuccessfully discharged, and an addendum failed to report on January 30, which stipulate to those violations, waive hearing on the violations.
Thank you, Mr. Watts. Mr. Alfaro, Mr. Watts has advised the court you do wish to waive your right to evidentiary hearing herein. Is that correct?
Yes, sir.
And Mr. Watts has advised the court you do wish to admit to being in violation of the terms and conditions of your probation as he has set forth on the record. Is that correct?
Yes, sir.
Mr. Alfaro, the court does find that you are knowingly and voluntarily admitting to the probation violations, and the court finds you're knowingly waiving your right to evidentiary hearing herein, and the court does accept the same. Recommendations for disposition from the state, Ms. Norris.
Thank you, Your Honor. As noted in the stipulations, defendant has had multiple violations, including not reporting. Would note for the court that he was initially placed on probation in this case in June of 2025. And at that time, Your Honor, he's criminal history score A, and the court did depart to allow him to be placed on probation. And Your Honor, one of the reasons the court departed was because he had gotten an evaluation and was going to be working on treatment. And Your Honor, some of the violations that he admitted to, that he was discharged from treatment unsuccessfully and that he's been using. So Your Honor, based on the fact that the court gave Mr. Alfaro a significant opportunity as a criminal history score A to be placed on probation again by departing, we would ask the court note that he's not amenable to probation, and the court does not have to do graduated sanctions because he was a departure case. We would ask the court revoke defendant's probation, and then be ordered to serve the balance of the underlying sentence. And I would note for the court, defendant is in the county jail on an unrelated municipal court matter. I believe he's it's a revocation on a municipal court case, so he is technically out on bond in our case. His jail time credit in this case, I think, is somewhere around 34 days, although we'll get official numbers from the jail for purposes of the journal entry, but we do believe that he is not a good candidate for probation and that he should be revoked and remanded to Department of Corrections. And the court will need to address additional attorney's fees and bids application fee as Mr. Watts was appointed in this case.
Thank you, Ms. Norris. Recommendations as far as disposition from Community Corrections Intensive Supervision Officer Christy Ashenfelter.
I have nothing to add, Your Honor.
Recommendation from Defense, Mr. Watts.
Thank you, Your Honor. You know, when Mr. O'Farrell was sentenced, we did do a departure motion. I was just going back and reading the departure motion. This was for Mr. O'Farrell, a first drug case in his history. And now we are a first revocation on a first drug case, and we're going to throw up our hands and do the easy thing and just send him off to prison. When I met with Mr. O'Farrell back in January, when we first had this warrant to show cause hearing, and the court may remember, Mr. O'Farrell struggled to communicate. I had some discussions with him. They were, to be perfectly blunt, disjointed, difficult to follow, difficult to understand, contradictory. He was clearly struggling with mental health problems. And the addiction is part and parcel of that, struggling with his mental health problems. It has taken us a while to get here. That was in January of this year. We are now, obviously, the 1st of May. I will tell you one thing. The Mr. O'Farrell I met with in the breakout room today is a far different person than he was in January. He is coherent. He understands what's going on. He is communicative. He is aware of where he's at and what he's doing, and aware of the struggles he's been through. It is a very different person. You may remember back in January, I thought we were going to do a stipulation. Mr. O'Farrell got into the hearing and it went completely sideways. And we ended up with a mental health evaluation and a competency evaluation, which we've now taken up. That's not the issue today. This Mr. O'Farrell is much more coherent and frankly, a pleasant person to talk to. And part of that is mental health. And as it will not come as to anyone's surprise that a significant percentage of my clients, I'm guessing a third to a half, have some sort of a mental health issue. And Mr. O'Farrell's case, that's the case certainly as well. But the important thing is, and Ms. Nelson is here to speak to the court, not so much on the mental health side, but on the drug treatment side. But the reality is those two things are related. One leads to the other, which leads back into the first, which feeds back into the second, and they become interrelated and interwoven in ways that it's almost impossible to separate the two. Person's mental health struggle with addiction because they're trying to self-medicate, which makes them addicted, which makes them struggle with their mental health because they have difficulties dealing with it, and the cycle just goes on. For Mr. O'Farrell, that cycle seems right now to be in a pretty good place. I won't say that he is cured. There is no such thing, in my experience, as cured when we're talking about this sort of thing. But he is a much better place than he was when I met him on January 9. He is cogent, as I said, he's pleasant to talk to. And most important, he is participating in the evaluation and treatment programs that he is taking part in, and it shows talking to him. He has now been in custody for some time, and I will be honest, that probably has something to do with it. That it's harder, I won't say impossible, but harder to get drugs while you're in jail. Far from impossible, unfortunately. Judge, I would recommend that the court impose a sanction of whatever the court believes is appropriate up to 60 days in this case. The court has the authority, because this was a departure, as Ms. North noted, to simply remand him to custody. And the court could do that. Our recommendation, or my recommendation, would be not to do that, to instead put him in custody for a time that the court believes is appropriate. He is currently serving some city time. I don't know how much time he has on this case since his arrest. He has been in and out a couple of times for various reasons. At one point, we struggled to get him in to do the evaluation because he was still struggling so much with the addiction. So he has some jail time credit here. I frankly don't know how much. To place him in a sanction for a time that the court believes is appropriate and give him an opportunity to complete this probation, and most important, complete this probation with a long-term treatment component. He can do this. My conversation with me this afternoon tells me he can do this. But as I mentioned to Mr. O'Farrell, and I've said a number of times to the courts over the years, we can remand him to custody. Doing so will not be helpful to anyone. It won't put Mr. Alfaro in a better place. It won't put the state of Kansas in a better place. It won't put the community in a better place. Mr. Alfaro will come out in no better shape than he's at right now, and probably much worse. We will spend, I don't know, $30,000 a year or so housing and warehousing him. And at the end of that, we will accomplish nothing. So that's my recommendation, Your Honor.
Thank you, Mr. Watts. Further input from Ms. Nelson with Substance Abuse Center of Kansas.
Yes, Your Honor. Mr. Alfaro voluntarily signed up for a drug and alcohol evaluation with SAC on 3/18 of 26, and then joined my class on 3/27 of 26. And since then, he's completed level 1 coherently and productively. In the last 6 weeks, we've also had 1 or 2 individual sessions where we've talked about him going to inpatient treatment, which was our recommendation. So if he were to not go to prison, we would work with him to get him into inpatient treatment and then follow up with aftercare. It would be outpatient treatment and then aftercare, which is roughly 4 months of continued treatment as long as he stayed on track.
And if I may, Your Honor, I'll mention one other thing. This just dawned on me. Mr. Alfaro is not our typical first-time drug. This is his first drug case at this point in his life, and that's not typical for my drug cases. Typically, persons are, as I hate to say this because I'm this to a T, Mr. Alfaro's age, have got a number of drug convictions behind him. He has struggled in his recovery with that and has relapsed. In the last 15 years, I can probably count on one hand the number of clients I have had on a drug case that at some point in their recovery didn't relapse. It's almost inevitable that you're going to have that sort of relapse. The drug abuse professionals I talk to tell me that it's almost necessary to have that sort of relapse if you're going to have long-term success. You have to understand what those triggers are. So I don't doubt that he's relapsed. Almost all persons who use drugs do. That does not mean they cannot be successful.
Mr. Alfaro, the court is in receipt of the recommendations as placed on the record today. The court has seriously taken the recommendation of the state that you are not amenable to probation. And the reason that you have been successful for approximately the past 6 months is you've been in custody. I've taken into consideration the experience and the statements made by Mr. Watts that he has only had very few clients that have appeared before the court in your situation based on your age and your drug convictions, that this is the first drug conviction. Therefore, the court will retain you on community corrections probation after you've served whatever time that you are sentenced in municipal court to serve, and then we'll place you back on intensive supervision with community corrections. Immediately after the hearing, I'll put you into a breakout room with Ms. Ashenfelter. The court will note, Mr. Alfaro, if you return back on this warrant to show cause docket, that the court at that point in time, in all likelihood, will find that you are definitely not amenable to probation. The only way for you to stay sober and off of drugs is to be in custody. And the court at that point would have no alternative other than to remand you for your sentence to the Department of Corrections. The court finds, based on your lack of financial wherewithal, being incarcerated, you do not have the necessary funds or fees to pay for court-appointed attorney fees or bids application fee. And the court makes inquiry if Ms. Ashenfelter and Ms. Nelson, if you wish to meet with Mr. Alfaro in a breakout room, after this hearing?
Your Honor, before we get
Yeah.
to that, he needs to be extended. His probation would expire in June. And then also is the court giving him 2 days, 3 days, 30 days as a sanction for the probation violations at this time?
Okay, is it correct that the time that he's serving currently is not associated with this case?
That's correct, Your Honor. He was out on bond. He has been revoked in a municipal court case. I'm not sure. He went into custody on 3/11, which I think might be the only reason that he's sober at this point in time, and you're able to understand him better than when he was out of custody back in January when we had the competency concerns. So he's been in since 3/11. I don't know how long he has to go on it, but yes, he was out on bond in this case. So he has very little jail time credit since we started this warrant to show cause back in December.
The order of the court today is Mr. Alfaro serve 30 days in the county jail once he has been released from his municipal court sentence.
Your Honor, he does need to have a 12-month extension of his probation so he can complete treatment, etc.
So ordered. The court extends his probation to May 1, 2027.
My inquiry, Your Honor, Mr. Alfaro, do you know what your out date is on the municipal court?
January 19th at 5:30. I got a year
January 19th of 27.
next year. Yeah.
So he'd be out February 19th, basically.
Your Honor, he's not amenable to probation at this stage. If he's going to be in our county jail for a year plus another 30 days, it sounds like you might want to revoke him after all, because he can't go anywhere and can't do treatment, which is apparently everybody's big concern with him, even though he failed to comply with treatment since June.
Mr. Alfaro, this does change the court's considerations and thought process. If you're going to be in the county jail on a municipal court case until whatever date you stated in 2027,
Yes, sir.
Mr. Alfaro, I find you not amenable to probation, and I do go ahead, the court revokes you from your probation that was previously granted through community corrections, and the court does order you to serve the balance of your sentence previously imposed with the Department of Corrections.
Was the court consider modifying that sentence at this point? He has an underlying of 40 months, got 142 days plus whatever he's had since that time on the warrants to show cause. I'm guessing 160 days, give or take, of jail time at this point.
And okay, so he served 168 and he'd be granted jail time credit of that much?
Judge, he had 142 days at time of sentencing. I'm kind of a ballpark guess. He's got some time since that time, maybe around 160 days, give or take. I don't know exactly how many.
Your Honor, actually, I don't know that he has any more. We'll have to double check with the jail. I know for sure that he has 142, which was given to him at time of sentencing, and information that I got from the jail doesn't show any time thereafter, and that was January 2nd of 2026. So I'm not sure that he has more than the 142, but we will double check.
Thank you, Ms. Norris. The court does grant Mr. Alfaro credit for time that he has served in case number 25 CR 51, subject to determination and with Ms. Norris to confer with Mr. Watts, and that would be a matter that could come back before the court if necessary. All right. At this point, anything further, Ms. Norris?
No, Your Honor, thank you.
And Mr. Watts?
No, Your Honor, thank you.
Anything further, Ms. Ashenfelter?
No, Judge, thank you.
There being nothing further to come before the court, court is in recess. Mr. Alfaro, good luck to you.